Thank you. Awesome. So welcome everybody. My name is Sydney Charnello. I work for Coconino County Superior Court, and I'm the mental health court coordinator and clinical liaison. So we have two presentations today. We have one about Rule 11, and then we have a second presentation about Title 36. So I will ask everybody to place your questions in the chat, and at the end of each presentation, we will go ahead and address those questions. And for anybody that is in the room, we will probably, when you have questions, we'll repeat your questions for the people in the chat, just so everybody can hear. But other than that, if there becomes any issues with audio, please throw it in the chat. We will have someone monitoring the chat. But if not, thank you for being here, and we'll go ahead and get started. All right, just making sure this clicker was working. So my name is Sydney. Like I said, I work for Coconino County Superior Court. I am currently the mental health court coordinator and the Rule 11 clinical liaison. So what we're gonna talk about today is specifically Rule 11 from just the court's perspective. My hope is to go through this with you guys and kind of talk about how it crosses over with behavioral health and how behavioral health works with the court on these Rule 11 cases. Do you have an attorney in the room to help me if I get anything wrong? But I will go over generally what Rule 11 is and my role as a clinical liaison for Rule 11 cases. So probably the biggest question that you guys might be asking is what's Rule 11? We say that a lot. It's thrown out there, but in I guess general terms, it's competency. So when there are concerns that somebody is not competent to stand trial, we kind of refer to that as Rule 11. So it's covered under Rule 11 of the Arizona Rules of Criminal Procedure. So that's why we call it Rule 11. It looks at people that have mental illness, defect, or disability. And these are people that either the court or their attorneys believe that they cannot assist in their own defense or help their attorney assist in their defense. So by law, those people cannot be tried in a court of law until they are found competent. So what happens when there are concerns of competency, right? What happens when either the court or the attorneys involved believe that somebody's not competent, they can't assist their attorney in their own defense, they don't understand the proceedings against them. Generally, what happens is the court or the attorney will ask for an evaluation. So the court on its own motion can ask for what they call a Rule 11 evaluation or mental examination. The terminology is the same thing. Generally, I see in this county that it's the defense attorneys that are asking for these evaluations. They're having trouble with their clients, understanding the proceedings against them. They can't really assist their counsel in their own defense. So they are asking the court by motion to have one of these mental examinations. But anybody can ask for a mental health evaluation. So the co-defendants, the court can do it, the state can do it, and defense attorneys can do it as well. So no later than 3 days after an expert is appointed to do these evaluations, the parties have to provide whoever's doing the examining mental health evaluation, they have to provide them with medical records and criminal history. So they have to be provided with some history. Yes.
So this is for people on the phone. My name is Michelle Darko, and I usually get those court orders. And what the doctor or the providers are requesting is the indictment and the police report.
Police reports.
So when it says criminal history, because it's for that particular case, I need the police report for that case.
Okay. And are you getting those?
Yes.
Are they getting them upon request?
Yeah.
Okay,
yeah.
Great. And that's probably a little more helpful than necessarily criminal history. Not everybody has access to criminal histories. Criminal histories are very tough to get. They're very protected. But as long as you guys are getting the records that you're asking for is the most important thing. There are pre-Rule 11 evaluations. So these are kind of smaller, shorter evaluations that kind of determine if there should be another longer evaluation. I've seen us moving away from those and just going ahead and asking for the full Rule 11 evaluation. But a lot of times lower jurisdiction courts might ask for pre-Rule 11s to see if there's any need for further evaluation. And oftentimes motions can include up to 3 experts to do evaluations, but generally the attorneys are stipulating to 1 to 2. So a lot of them start with 1 and then might come back and ask for a second evaluation later. It really just depends. So jurisdiction. So who does these Rule 11 cases? That would be Superior Court. Superior Court has exclusive jurisdiction over all competency hearings. There can be some cases where an administrative order says that a lower jurisdiction court can handle such cases. However, here in Coconino County, Superior Court has jurisdiction, they all go up to Superior Court. So if they're coming out of city court, justice courts, and that's Flagstaff City Court, Williams City Court, and any of the lower jurisdiction courts that have these cases, they're going to be waived up to Superior Court for competency proceedings. If there at any point the defendant becomes competent or is found competent, that case should be transferred back to said court that it came from, and proceedings should continue without delay. There is a special rule that if a court finds a person has been previously found incompetent, under this rule, the court can hold a hearing to dismiss any other misdemeanor charges against them. So, reports. So once the court has appointed an expert, so here in Coconino County, I would say 99% of the time, the guidance center here where we are is who is doing these competency evaluations. You have 3 providers here that often get appointed to do these evaluations. So once these evaluators have completed their report, it must be filed with the court no later than 10 business days after it's completed. I'll say our evaluators are very great at getting these reports filed. When the court receives the report, they'll send it out to the defense attorney. I don't know if you guys are getting these directly from the provider as well.
Typically getting them from the court.
Yeah. So the court generally will send them, and then the defense attorney is going to go ahead and read through that and redact any information that needs to be redacted. And then they need to provide that to the state no later than 3 days after receiving the report. And then no later than 30 days after experts have given their reports to the court, should the hearing be set to determine competency. Now, that time can be extended because of many different circumstances, but generally they want to get that set within 30 days of that report being submitted to the court. And those competency hearings, they can go a lot of different ways. The court can enter findings just based on the report, if that's what the parties stipulate to. So if defense and state agree, what's in this report, we agree on, we want to agree that this person is A, B, or C, they can just stipulate to that in a written motion or orally. However, if there's, times where people don't agree or there's more evidence, these hearings can become what are called evidentiary hearings, where attorneys can present other evidence, they have witnesses, and those are generally separate hearings. So this can be drawn out depending on the complexity of the case. And as we see, cases are more complex than others, and there's a lot more information that attorneys want to present on either side. So there are quite a bit of range of outcomes. I guess not a range of outcomes, but a range of things that can happen with all of the outcomes. So you generally have 3 things that can happen. Somebody is competent, they're not competent, but they're restorable, or they're not competent and they're not restorable. So when we say restorable, we are talking about, can they be restored to competency? Can they be given some sort of education that can get them to a place where they're competent to stand trial, where they can work with their attorney effectively on their defense, and they can understand the proceedings against them. So like I said earlier, if somebody is competent, then proceedings should just continue without delay. And when I say without delay, it's as quick as the court can allow with setting hearings and whatnot. But if someone is found competent and it's like a superior court case, that case will just continue on the superior court calendar. Cases that are coming from lower jurisdictions are going to be remanded back to lower jurisdictions. So things coming from Flagstaff Justice Court or Williams City Court those cases are gonna go back to the court that they originated from. And that's obviously the easiest outcome and the least complicated outcome. So someone can also be found not competent, but restorable. And there's a couple different options that can happen with these cases. And it just depends, again, on the complexity of the case and what is going on with the defendant. So if someone is found incompetent, the court can either dismiss the charges on the state's motion, or they have to be ordered to a restoration of competency program. So if the court or if the evaluators believe that the person can be restored within 15 months, then oftentimes they'll be sent to a restoration program. However, there are certain circumstances where these cases do get dismissed. Not all people who are found not competent but restorable go to restoration. Sometimes these cases are dismissed. This is going to vary in every jurisdiction that you go to, in any courts that you go to. Here in Coconino County, often I would say our prosecutors lately are really looking at these cases and looking at people's charges, and if it is in the best interest to send them to a restoration program. And if not, then the only other option is to dismiss the case. So that is happening sometimes, and that is one of our first intersections of where we can try to get the person set up with some kind of behavioral health services, because if their case is going to be dismissed, that means they're going to be released from jail. And if they're struggling with their competence, they're generally struggling with a mental health issue, not always, but generally. And that's one of the first points where we can try to engage them in behavioral health services. But oftentimes people get sent to restoration programs, and we'll talk about what restoration programs are in a second. And the third outcome that can be found is not competent, not restorable. So this is, when the evaluators don't believe that within that specific time frame, right, that the person can be restored to competency. So there's a couple of different things that can happen in these cases. So the first thing is that the person can be remanded to an evaluating agency approved and licensed under Title 36 for civil commitment. So civil commitment in Title 36, that is our civil commitment here in Coconino County. That's here at the Guidance Center. And you guys will get a little more information in our next presentation about civil commitment. But this is essentially remanding someone to see if they meet criteria for involuntary admission for treatment. So they can't be restored through a restoration program. This is the court remanding them to the appropriate contracted agency, which would be the Guidance Center, to see if they meet criteria for involuntary admission. So that's one option. Another option is the court can appoint a guardian ad litem to investigate whether or not that defendant may be a good candidate for a guardian. So the public fiduciary can be a guardian ad litem. Legal defender's office can do guardian ad litem. I believe you guys get appointed for that.
Not in these cases.
Not in these ones?
No.
Okay. So public fiduciaries generally are the ones getting appointed. And that's just an investigation to see whether or not a guardianship or a conservator might be appropriate for that defendant. And then the third option, which generally is going to happen with the first two, is the case is going to get dismissed. Generally, all these cases are getting dismissed, whether or not the person is if the court's trying to remand them to the evaluating agency for involuntary commitment, or they're trying to see if a guardian is appropriate. These cases are going to get dismissed because these defendants that kind of fall in this category of not competent but not restorable can't be tried if they're not competent. It's a lot. It can get a little bit convoluted and confusing. But that is probably the one I see the least. I would say most people, like most evaluations we see, are not competent but restorable. that with some kind of education and treatment, or whatever range of treatment and education and medication looks like, people can be restored to competency. So what is restoration of competency? I keep saying restoration of competency, or we call it RTC. So I'm sure in the behavioral health world, you guys have a lot of acronyms. We also have a lot of acronyms in the criminal justice world. So you might hear people saying RTC, ARS RTC, YRC. So in general, restoration of competency focuses on education around understanding the charges that you have against you. It's understanding the court process and how it works, and the court players. So your attorney, the judge, the state, what are all their jobs? It's helping you understand the proceedings against you. So it is education. It is not treatment. Coconino County contracts with 2 restoration to competency programs, and they are both inpatient programs. So we contract with the Arizona State Hospital. They have a restoration to competency program, and that is in a hospital setting. It's still we call it inpatient. It's not really in custody. And then the Yavapai restoration to competency program is actually in their county jail. So it is an in custody program. We currently do not contract with any out of custody restoration programs, but they do exist. There are providers that can provide this education to defendants out of custody. We don't contract with any of those programs as of now, but that it is possible to do restoration of competency, not in an inpatient or in custody setting. So those are 99% of the time since I've been doing this job, those are the 2 places that if somebody gets ordered to participate in restoration of competency, one of those 2 places is where the defendants are going to go. They will be furloughed from the jail and taken to those facilities, and they will engage in restoration education until they are competent, if it happens within that specific time frame. So individuals that go work with, they generally work with a psychologist, a psychiatrist, and a social worker on their restoration. So medications in this instance are administered as needed and on a voluntary basis. So a big kind of cornerstone of restoration is you cannot involuntarily medicate somebody in this process and in these programs. There's only one court route that you can involuntarily medicate somebody, and it is not through restoration to competency. So unless you have a specific hearing to determine if involuntary medication is necessary, when people get sent to these programs, they cannot be medicated against their will. It is given on a voluntary and as needed basis. And I have seen people that go to restoration that don't necessarily need medication. They really just need a lot of time with the education. There are many people that go to restoration and they will take their medications voluntarily. And if there are individuals who go to these restoration programs and the psychiatrists believe they need medication and they're not going to be restored without the medication, there is a path for that. The individual will have to come back from the restoration program, and the attorneys are generally asking for a very specific type hearing to present evidence where the court can decide if involuntary medication is necessary. So that doesn't happen often, but it does happen because there are individuals that their restoration is medication dependent. But there are also individuals that just need a little more time and help with the education portion. And when the court sends somebody to these restoration programs, they order the treatment supervisor to submit reports. Those also get sent to defense counsel, and they get sent to myself as a clinical liaison at the, I want to say 60, 120 days they get sent. And in each of those evaluations, they're going to go through the education portion of what the defendant has been doing. They're going to talk about their meetings with the social workers. They're going to talk about their meetings with the psychiatrist. Are they on medication? What kind of medication are they on? What the doses are? Are they voluntary with their medications, their behavior? They're going to talk about all of the things this person is doing in their programming. And then they're also going to give an opinion about competence. So the first couple of reports we see, they might say, no, the person is still not competent right now. And then once we get a final report, That is generally the last, so when we see final report, that'll be the report we're getting from the treatment supervisor saying, okay, we believe that the person is competent, here's all the medications they're taking, here's all the programming they've done, and they're ready to leave. So once they leave those programs, they will come back generally to the Coconino County Jail, because I will say 99% of these individuals are in custody. They're not out of custody. We have a small group of people that stay out of custody for this. But generally these people are in custody, so the jail will bring them back up here. And the court has another hearing regarding competency. The court will set that hearing once they receive the final report, and they're going to do, again, a competency hearing, and the attorneys, they might agree, and they might say, yeah, we agree, or stipulate to competent, not competent, and then the case proceeds. It can get complicated after restoration, and cases might kind of start over and go back through the Rule 11 process if there are questions about someone's competency coming out of restoration. It's not black and white. I'm sure everybody in here is aware that when we're dealing with individuals that have serious mental health issues, or cognitive delays or deficits, it's not black and white. And so sometimes these cases can be very complicated, and even post restoration, there might still be questions of somebody's competency. So this is kind of what I talked about earlier. So if after restoration, somebody's found competent, whether the attorneys are stipulating it or if that's what the court determines, the case is going to proceed without delay. It's going to continue. If there's a finding of continuing incompetence, if the person, if the court finds that they're still incompetent, and if there's like a likely probability that they can regain competence, they can modify the treatment order for an additional 180 days, or the time provided for the defendant's maximum sentence. So whichever is less. So there can be an extension up to 180 days of treatment, if there's a high possibility that they will regain their competence. I don't see that happen much, but it is possible. And then the charges can get dismissed. So if somebody is found incompetent, even after restoration, and the evaluators do not believe, or the doctors that they work with do not believe that they will regain their competence, the case can be dismissed. And and similarly, again, so when we talked about when people are initially found not competent and not restorable, the same things can happen with dismissals after restoration if they're found not competent and essentially not restorable. So like I said, I'm the clinical liaison for Coconino County Superior Court. This is a new position. So our Arizona state statute requires the appointment of a clinical liaison. It's a very small, short statute that requires that anybody post-restoration, so anybody that's gone through a restoration program, gets appointed a clinical liaison. So I get appointed on these cases when people are sent to restoration. And essentially I'm there to monitor continuity of care following restoration. And I act as a liaison between the court and treatment. And I can prepare written reports to the court. I haven't done much of that, but I can, if needed, provide written reports to the court. So essentially I'm coordinating care. I'm coordinating care between the court and the treatment providers. I do get copies of all the Rule 11 evaluations, and I do get copies of all the reports done when people are in restoration. So sometimes, like if there's a snag, if I get them and other parties are supposed to get them don't, I can help out with that. I can review the reports to see where the person is in their treatment, and I can start working with these individuals when they come out of restoration on connecting them with care. So what exactly does this coordination of care look like? Well, before they go to restoration, I don't have much of a role. I generally step in when they go to restoration and post-restoration. But but I can keep track of them while they're in custody and while they're at their restoration facility. I can obtain medical records if needed. If anybody ever needs help getting medical records for these cases, I can try to help to the best of my ability as long as I have the appropriate releases. And I can start to check the status of their insurance coverage and their enrollment with behavioral health facilities. So the biggest thing with coordination of care is doing what you can as soon as you can. So I can start to try to figure out if these individuals are connected to services already. That way, when they come back from restoration, I can try to help them continue those services or get established with those services. And, so during and after restoration, like I said, I'll review progress reports submitted by the restoration facility. And when they come back, I can work with the jail staff. And I say monitor, but I don't have much to do with monitoring really, but I can check in with the jail staff regularly to see if individuals that are supposed to be taking medication are still taking them. Again, medication in this case is voluntary. So they don't have to take their medication, but I can check in with the jail staff and I can provide that information to the court. And then I can also meet with the defendant to begin coordinating care. When people come back from restoration, I always make myself available to them. I will go meet with them. If they don't want anything to do with me, unfortunately, I won't force myself. I'm not going to force coordination of care on somebody. So sometimes defendants are like, no thanks, like I don't want anything to do with you, and that's fine. But I will go meet with them. I will let them know what I have to offer, what I can help them with, and I can help them get connected to the best of my ability. So again, coordination of care is the biggest piece of this that I kind of wanted to highlight on. I'm not an attorney. I sped through this pretty quick, but the biggest piece of this that I think is the most important for the court and behavioral health is this is where our crossover is coordination of care. So a lot of these clients that have questions about their competency, it is because of a mental illness. There are a chunk of cases where people maybe have cognitive delays or deficits, or they're dealing with something like TBI, traumatic brain injury. But a lot of these individuals have been connected to services, are connected to services, will need to be connected to services. So that's where I can come in and work with you guys as behavioral health to get them connected, to get them enrolled, connecting them with family or friends, wherever they're from. They might not be from here. And I can help them so that eventually, if they do get out of custody, if they see themselves walking out of the jail one day, that they walk out to something and not to nothing. So my biggest thing that I always say is decisions about coordination of care are made with the defendant, not for the defendant. So again, I will not do anything that the defendant doesn't want. If they don't want me involved with them whatsoever, I will not get involved. And I will help them with what I can help them with. And that way, when they're done with their criminal case, hopefully not unfortunately, the reality is not everybody's going to walk out of the jail. Some of these defendants are going to go to prison and they're not going to walk out of the jail. But for the defendants that do walk out of the jail at some point, hopefully they can walk out to something and not nothing. So that's whether that's getting them enrolled with a local provider, re-engaging them with a local provider, making sure medications are available when they get out of the jail. Those are all things that I can help with and that I can assist behavioral health with. So that is my shtick. I'm going to just pop open the chat, but do any of you guys have any questions? I know I kind of sped through that and went quick. It was kind of a lot. I don't know if anyone has any questions. All right, cool. All right. All right, so I'm gonna hand it over to Jillian and we're gonna go ahead and get started.
Thanks, Sydney. My name is Jillian Marini. I'm an attorney with the Coconino County Legal Defender's Office. And I've been handling the Title 36 cases for about 8 years now. My office handles these cases exclusively, so the public defender's office doesn't typically handle these cases. Some of you might not know what court-ordered evaluation is, but in a nutshell, it's when someone is involuntarily committed to a psychiatric facility for evaluation and potentially further treatment. Because they are committed on an involuntary basis, they are appointed counsel to advise them of their rights and to protect their rights while they are being hospitalized. So from a legal perspective, Title 36 cases are very formulaic and procedural, black and white. And I imagine that for behavioral health professionals, that's a little bit frustrating because treatment and care probably is not formulaic, and there's probably a lot of gray areas when it comes to that. But basically, there are certain steps that must be followed along the way. And if they are not followed, those are avenues for the attorney to get those cases tossed out, essentially. So how do people end up in the psychiatric unit in the first place under Title 36? So there are a couple of ways for this to happen. One of the most common ways is that there's an application for emergency admission that is filed. And once that is filed, an examination is conducted. And based on that examination, there are a couple things that can happen. The person ends up hospitalized on an emergency basis, or it could turn out that the person doesn't really meet the criteria for hospitalization and they're sent on their way. So that would be discharge. Or the individual is offered an opportunity to be voluntarily admitted for an evaluation and further treatment. So if they are admitted on a voluntary basis, then they actually do not end up with an attorney because they're no longer there against their will. So they will proceed in the unit on a voluntary basis. There are ways that counsel can end up getting involved later. I'll address those a little bit later. But let's say they meet criteria, they refuse to sign in voluntarily, and they're admitted into the hospital, or the psychiatric facility. I'm using those terms interchangeably. So if that happens, then a petition for court-ordered evaluation must be filed within 24 hours of their admission. And that's what ends up triggering the appointment of an attorney to their case. There two types of evaluations can occur, and I could tell you that the most common is a custodial evaluation. And that's because most of the people are already presented to the psychiatric unit and are typically in crisis at that time. So they end up being held for the purposes of conducting further evaluation. There is an option for what's called a non-custodial evaluation, where the evaluation can be set by appointment later. I think you can imagine why that's pretty rare, because if a person is in crisis, they probably need to be hospitalized right away. The way I typically see this being used is for people who are actually in the jail and are showing some signs that they have a mental disorder and that they are either a danger to self or others, or persistently or acutely disabled, and that they need to be evaluated for further treatment. So because they're in the jail at that moment, they're not being admitted to the psychiatric unit right away. And that's when I see the order for non-custodial evaluation come into play. I probably should back up a little. I thought I had a PowerPoint for this, but to talk about the actual criteria that's required for this admission. So the way the statute is written is that the person must meet certain requirements for a petition for evaluation to be granted. And so they must be either considered a danger to themselves, a danger to others, persistently or acutely disabled, or gravely disabled by reason of a mental disorder. And so these evaluations will allege that a person meets one or more of those criteria and will provide some facts for a judge to review, because again, a judge actually has to sign off on this. I'm sorry, I'm trying to, I usually do this presentation for lawyers, so I'm trying to adapt a little bit that they're behavioral health professionals here, of course. So I'll just back up. So when I say order for custodial evaluation, that order is coming from a judge, just to be clear. And that's what would grant the psychiatric unit the authority to hold the person for the evaluation period. So then once that order is granted, again, that allows the person to remain in the psychiatric unit. It's for a period of 72 hours, but it does exclude weekends and holidays, and it also excludes kind of that initial admission time. So that 72-hour, this colloquially, people call it a 72-hour hold, and it ends up being a lot longer than that. So I try not to use that language with clients because they end up getting pretty frustrated and feel mistrustful because, you know, if you, especially with a holiday, you know, if someone comes in right before Labor Day weekend, for example, as you can imagine, that time, that 72-hour hold can end up being like somewhere around 6 days for them. So I try not to use that language, and instead I just calculate for them based on from the time of the order for evaluation is filed, excluding any weekends or holidays. I say, this is when you will be released unless the guy, and I'm using the guidance center because they're in Coconino County, they're the individuals who do this process for us. Unless the guidance center proceeds with a petition for court-ordered treatment. So we'll get there in a minute. So there's a couple of outcomes during that evaluation period. So one, the person can once again be admitted on a voluntary basis. So maybe while they're there, they stabilize a little bit and they say, yeah, actually, I feel like I should be here, and I'm going to sign in voluntarily. So, you know, once they do that, they're again no longer under a court order to be there. However, if they revoke their voluntary status, they are required to be discharged within 24 hours, unless if the guidance center feels that they're not ready to be discharged, then the guidance center could then start that process of petitioning for court-ordered treatment, which would allow certain things. I'll get there. I don't want to make it too confusing. The other option is that after the evaluation period, the person is discharged. It's actually determined that so maybe they presented and they might have been acting bizarrely or something like that, but it cleared up and they no longer think that they have a mental disorder, or they just think it's not, for whatever reason, it's not appropriate to continue the process. The person can be discharged. And then the final option is that at the end of that 72-hour period, if the guidance center feels that the person needs further treatment and is unable or unwilling to voluntarily accept that treatment, they could petition the court for court-ordered treatment. And that's really where the attorneys end up stepping in the most. So during the evaluation period, we typically just call the clients and review with them their rights while they're during the evaluation period, what rights are afforded to them. But we're typically not holding hearings during that time period. And remember, it's a pretty short time period, unless we notice that there's some deficiency with the paperwork that was filed. Then we might be acting on their behalf during that stage. But this is really where the attorney involvement comes in. And that's because there are some pretty significant consequences to the individual for being, if they're court ordered to receive treatment. So just prior to the expiration of that 72-hour evaluation period, the Guidance Center will file a petition for court order treatment, again, if they think the person needs further treatment. And there's a couple options here. So in theory, the court could deny the petition for court order treatment right off the bat. I think that's very rare. There would have to be some significant legal deficiencies in the petition. Like maybe there's not a doctor's affidavit to support the petition. It rarely happens at that stage. What's more likely to happen is an order for further detention is issued, because remember, at this point, the 72-hour evaluation period has expired. So a new order is issued to detain the individual until their hearing on the petition for court ordered treatment. And that hearing has to be held within 6 business days. And the potential outcomes of that hearing are that the person could be ordered to receive treatment, or the petition could be, I should have probably put there, denied by the judge rather than dismissed. Okay, so now I recall how I did this. I kind of did it flipped. I wanted you guys to have like an overview of the process, and now I'm going to go into a little bit more detail. So patients do retain rights when they are in the psychiatric facility. I've listed some of the rights here. I'm not going to review each one. I'm going to review just a couple of the really important ones. So they do have a right to request an independent evaluation. That has proven to be incredibly difficult in Coconino County, which is unfortunate. Part of that is because the Guidance Center typically is the agency that does all of our evaluations. So it's really hard to find outside providers to do the evaluations, and they're usually out of county, which, as you can imagine, creates a delay just to get it scheduled and to have the evaluation completed. During the evaluation period, they also have the right to refuse all treatment, which means medication, right? And the only time medication can be administered is if they are a danger to themselves or others on the unit. Chemical restraints is, what it's called. Chemical restraints can be used. So medication can be forcibly administered against the person's will, if, again, they are proving to be a significant danger to themselves or to someone else on the unit. So this is what I was just touching on. So they also have a right to be free from restraint and seclusion. And so specifically, a person should not be subjected to seclusion or mechanical or pharmacological restraints, except in the case of emergency for the safety of the person or others. Unfortunately, it does happen often. When I receive these cases, I do also receive access to my clients' medical records. And part of this process requires that any pharmacological restraints, when they're used, that it's documented in their record. And so we do see it. I'm going back now to the standard that has to be met in order for someone to be evaluated or treated under Title 36. So this is the definition of a mental disorder. And one, again, I'm not going to read all of this on the slide, but one of the important factors of this is that a mental disorder has to be distinguished from conditions that are primarily those of drug abuse, alcoholism, or intellectual disability, unless those things are present in addition to the mental disorder. So sometimes people will come into the psychiatric facility, and it turns out that the behaviors that they're displaying are actually the result of drug use only and not the result of a mental disorder. And so hopefully, during the evaluation period, that will become more clear and the individual would end up being released because there would be no basis to support a finding of a mental disorder. Also interestingly excluded from this are character and personality disorders. And depressingly, the declining mental abilities that directly accompany impending death. So, talking more specifically about the allegations, I told you there are 4. So, one of them is danger to self, and this is the definition of danger to self. Sometimes danger to self is used pretty broadly to mean that a person simply can't safely navigate the community. I personally, obviously my perspective as a defense attorney is that that's not the purpose of this allegation. The purpose of this allegation really is that the person has some significant suicidal ideations and that they have a plan and that there's an expectation that the threat of harm to themselves would actually be carried out, versus just someone who, because of their mental disorder, is, disoriented and walking around in the community. The allegation of danger to others, in order to prove that the petitioner, which is again the guidance center here, would have to prove that by reason of a mental disorder, the person's behavior can reasonably be expected to result in serious physical harm. So it can't just be any physical harm, it has to be serious. And then this is the allegation that we see the most with court-ordered treatment. So I can tell you it's very rare for an individual to be court-ordered to receive treatment if they're only a danger to themselves. And I think the reason why that is because there's a lot of safety planning that can be done to help individuals who are in that situation. Whereas it's a little bit more difficult, I think, when it comes to an individual that is considered persistently or acutely disabled. So for someone who's persistently or acutely disabled, they would have to have a mental disorder that significantly impairs their judgment, reason, behavior, or capacity to recognize reality. So these are typically individuals with schizophrenia type disorders or delusional disorders, or like bipolar with delusional disorders, end up falling in this category here. And that if this person is not treated, there's a substantial probability of causing the person to suffer or continue to suffer severe and abnormal mental, emotional, or physical harm. And then, it goes on and on about their capacity to make informed decisions about treatment. And this is the allegation that we most commonly see for court-ordered treatment. The last one is grave disability. I haven't talked too much about this one even initially because it is pretty rare. It is a high standard to meet and it triggers additional requirements in the petition. So that might be the reason why it's rare. But this is when the person is basically completely unable to provide for their own basic physical needs by reason of a mental disorder. And some of the additional requirements that are triggered when this is the allegation is that the public fiduciary has to be notified to start an investigation to see whether a guardian is appropriate. The other reason that this allegation is used, I think, rarely is because the person also could be, if they're court-ordered treatment, if they are court-ordered to receive treatment based on having a grave disability, they can actually be detained for up to 365 days, so 1 year, which we'll go into some of those timeframes so you can see the difference. So these are this, so now that I've gone over, you know, what the mental disorder is and what it, which allegations can be made in the petition, this is the process for actually filling out an application for emergency admission, or I should say, these are the requirements for filling out an application for emergency admission. So the applicant must actually have, you know, this personal knowledge of the facts that require admission. It can't be like, well, I heard from so-and-so that X was acting strangely. A lot of times these applications for emergency admission are filled out by behavioral health techs at the hospital, so FMC, or by crisis workers right here at the guidance center. I would say those are probably the two most common. It's definitely more rare for these applications to come from family members. I think maybe just the nature of Flagstaff and Coconino County, we have a lot of transient people who are coming through here and unfortunately are ending up hospitalized. So I don't see a lot of applications filled out by family members, but the application would allege that the person has a mental disorder, that they are either a danger to self, danger to others, persistently or acutely disabled or gravely disabled, and that without immediate hospitalization, they're likely to suffer serious physical harm or serious illness or to inflict serious harm on another. And by the way, they can be taken into custody by law enforcement without a court order. This seems to be like an ongoing conflict about that. Law enforcement doesn't typically want to do that. And I'm not sure why. I think it might be like a liability thing, although the statute is abundantly clear that they will not be held liable in this situation. But yeah, for whatever reason, that seems to be an ongoing issue. So stand at 3.
We have the room till 4.
Oh, okay.
Yeah.
I was like, I'm in trouble time-wise. I'm in trouble. Okay. So again, going back to this petition for court-ordered evaluation, after the application is filed, there's an examination and by someone here at the guidance center. And the purpose of that is to, you know, make sure that because anyone can be an applicant, you know, I can be an applicant, anyone off the street can be an applicant. So they want to make sure that someone with like a mental health background is making sure that this person actually meets criteria to be hospitalized. You wouldn't want someone, you know, who has like a family member who's just trying to get them hospitalized for no reason. So again, after the application is filed, the petition for court-ordered evaluation will essentially allege very similar things to the evaluation, but usually in more medical terms, because those petitions are in fact completed by doctors at the guidance center. And if the court grants the order, that means that the court believes that there's reasonable cause to believe that a person has a mental disorder and is either a danger to self, danger to others. I'm going to just go with the abbreviations, PAD or GD, and that the person requires immediate or continued hospitalization before the proposed patient's hearing on court-ordered treatment. Now, a person does have a right to a hearing to determine whether the person should be involuntarily hospitalized during that evaluation period, during that 72-hour hold. It's very rare, though, that we have those hearings here. I guess I'm not sure what's going on in other counties. I think part of the reason why it is more rare is that, I mean, that 72 hours goes by very quickly. It could take some time for me to even receive the order from the court and then get in contact with my client, determine whether they even have a good basis to support a request for a hearing, to determine whether they should be held for that 72-hour period. As you can imagine, by then the time period's up. it's also hard to get in front of a judge here. So typically when that happens, it's usually already after the petition for court-ordered treatment has been filed and someone is requesting a continuance on that hearing, which would detain the person even longer. Usually at that time, I will make an argument that the person should be released from the hospital pending their hearing on court-ordered treatment. And usually I lose. So
You're fine.
a couple. Yeah, so again, after the end of that 72-hour period, the person, you know, they might be admitted on a voluntary basis, they might be discharged, or if they're still refusing medications, or they're still, from the doctor's perspective, suffering from a mental disorder and are DTS, DTO, PAD, or GD, and in need of treatment, then they will go forward with the petition for court-ordered treatment. The petition itself needs to contain all of the things that I listed out there. Two of the main things that I'll highlight is that it has to have 2 affidavits from the physicians who completed the evaluation on the patient, and it must have facts to support that the patient is unwilling or unable to accept voluntary treatment. So the court from there will go ahead and order the detention of the patient pending the hearing. If the court determines, though, that the patient is likely to present a danger to self or others before the conclusion of the hearing or is not likely to appear. So again, in theory, the person could be released pending the hearing on court-ordered treatment. But these things happen quickly. Those hearings have to be set within 6 days, excluding weekends and holidays. So as the attorney of these cases, we are afforded certain powers and duties. We are able to access medical records without a release of information. We also are supposed to meet with the patient within 24 hours of our appointment. So typically we end up meeting with the patient twice because we'll meet with them at the evaluation stage. And then again, if it goes forward with court-ordered treatment, we are required to meet with them again to discuss those next steps. It's our job to explain to patients their rights pending court-ordered treatment, the procedures, and the alternative of becoming a voluntary patient. That being said, it's entirely up to the doctors whether they are willing to accept someone on a voluntary basis. So it's not just a matter of saying the magic words like, oh, I'll stay here, right? The doctors usually want more than that to believe that the person is compliant with treatment and willing to be an active participant. I also have the ability to interview the doctors and any other witnesses and to investigate alternatives to court-ordered treatment. And I can be held in contempt of court for failing to do that. So the hearing also has some very specific procedures and rules. I think by now you could see like it's very time oriented. So those are some of the ways that these cases, you know, get kicked out or kicked back, is because there are very strict requirements about, you know, you must file this at this time, and you must offer the patient voluntary treatment at this time. So these cases are very procedural in nature. So when the hearing is held, the patient must not be so impaired by medications that they cannot participate in the hearing. So an example of that would be that if the person had to be chemically restrained right before their hearing and they're like completely sedated, you know, we can't go forward with the hearing because they wouldn't be able to actively participate. The patient does have the right to attend and participate. Their attorney must be present at every hearing. This is a full-blown evidentiary hearing. So we cross-examine witnesses and we could present evidence on our own behalf. Typically what these hearings look like is that the same two doctors who prepared the affidavit that accompanies the petition for court-ordered treatment, end up testifying to their personal observations, and based on their medical opinion, why this person, falls within these 4 categories. There's also a requirement to have some testimony or written statements from acquaintance witnesses as well. In our county, we typically rely on written statements rather than having more testimony. So because this is an evidentiary hearing, and the burden of proof is on the petitioner, I should say these hearings do invoke some pretty significant liberty issues, right? A person can be forcibly medicated. They can be detained against their will in a facility for, under gravely disabled up to 365 days. So that's why they're appointed counsel automatically. But also that's why the petitioner has what we call the burden of proof. So it's entirely up to the guidance center to prove by clear and convincing evidence that the person has a mental disorder, they fall in one of the 4 categories, that they're unable or unwilling to voluntarily accept treatment, and that they're in need of treatment. They have to prove all of those things. If they do, then these are what so the total period of treatment shall not exceed 365 days, 1 year, but the inpatient period is limited by those timeframes. So if they only allege that the person is a danger to self, they can only remain inpatient for 90 days. Danger to others or PAD is 180 days, and then gravely disabled is 365 days.
Can you talk about tolling?
Yeah, sure. I don't think I have that in here. It sure does. Yeah. So if a person, let me just tell you practically how this works after someone is court ordered to receive treatment. So if the guidance center meets their burden and the individual is court ordered to receive treatment, I can tell you that they almost never stay in the hospital for, 180 consecutive days. That's not going to happen. The guidance center doesn't have the space. This is an acute facility. What they do instead is, at that point in time, they are allowed to forcibly administer medication because they have a court order saying that the person must comply with treatment. And so, hopefully by then the patient is on board. Sometimes they're not, and they have to be forcibly administered the medication. Once the person is deemed stable by the doctors, they will be released to receive treatment on an outpatient basis. And what that looks like is that the person would then come to outpatient appointments and to address like medication concerns, sometimes to even be administered medication if they're on a long acting injectable. Sometimes it might include some therapy services, things like that. If they fail to show up for their outpatient appointments, at any time, the guidance center can pull them back into the hospital and use up some of those inpatient treatment days and forcibly medicate them. They don't need any other court order. So I'm not involved at that time because there's already an order that gives them the authority to do this. Now, sometimes, a lot of times actually, the patients disappear. And when they disappear, the guidance center files a basically an unauthorized absence notice with the court, which can extend their treatment period beyond the 365 days. So let's say they're on day like 70 of their court ordered treatment and they go AWOL. The guidance center can file the notice, and they will, from that point in time, they will be given another 365 days to continue to treat them. Unless if the person returns, that's a different story. Then that time that's told, that specific time period, just gets added on to the end. I feel like that was very confusing.
No, you said it right. So just that, like if they're on tolling for 30 days, we just add that.
Correct.
So
yeah,
so they're actually on COT for 365 days.
Yes, so
It
there's,
just gets added to the end.
it would get added to the end.
Yeah.
Yeah.
And then we have the option that if they're on tolling for, I believe it's 180 days,
Mhm.
then we can decide to drop the title. And so we file with the courts and
Yeah.
say, you know, we haven't seen them for
Mhm.
over 180 days. We've tried X, Y, and Z to do that. You want to drop the title, and that way we're not responsible for them. Because there are things that we have to do during this 365
Yes.
days. And also if they do something, we're not responsible for them.
Yep, definitely. So once someone is court ordered to receive treatment, again, through that time period there, but it's for a whole, the combination of inpatient and outpatient treatment is for a total of 365 days. There will be a treatment plan for them. The treatment plan will include, you know, which inpatient facility they're being treated at. Again, in Flagstaff, we only have the guidance center, but because we have a lot of people who are coming from different places, sometimes their inpatient treatment, you know, we might shift it down to a different facility. There will also be a recommendation of where they'll get their outpatient treatment. Now that they have a couple more options, right? Because like Southwest can do the outpatient treatment, for example. So their outpatient facility might be anywhere else in the state of Arizona. It will also talk about what their medication requirements are, and the conditions that they must meet in order to be eligible for outpatient treatment. Those conditions are outlined below. I would say that the most important ones are that they're medication compliant and they're attending all their outpatient appointments. Because if they don't do that, they can get pulled back into the guidance center to, I don't want to say serve, that sounds so, that's like my criminal law side coming out, but to use up those inpatient days, right? Realistically speaking though, what that typically looks like is that the person, unfortunately, what it typically looks like is that the person decompensates and they miss their appointment, they go missing, they decompensate in the community, and they either end up in the hospital or the jail and then get presented back to the guidance center to use up some of those inpatient days to stabilize them. Oh, I do have a PowerPoint on the unauthorized absences, but we already addressed that, so that's great. After someone is court ordered to receive treatment, they do have a right to judicial review. So there are actually a couple of options. So one of them would be, you know, filing an appeal to say that the lower court, like the judges here, made the wrong decision, putting the person on court ordered treatment in the first place. And usually the basis of that would be that, you know, there's a belief that the judge didn't follow the law in making the decision. More commonly, we would use this right to judicial review that happens every 60 days. And typically those cases are individuals who, you know, they might have decompensated, but they got back on track and they feel like they can treat themselves voluntarily, that they don't need to be under court order anymore. And so we would ask the court to say, we would say, yeah, we know you made this decision 60 days ago because you believe that they needed to be on court ordered treatment, but we don't believe they need to be on court ordered treatment anymore. And we think they should be released from treatment. Those happen pretty rarely also. And part of the reason why is after individuals are court ordered to receive treatment, it's actually really hard for us as their attorney to keep track of them. A lot of people maybe aren't from here, don't intend on staying here, or they go on an unauthorized absence, so we have no idea where they are in the first place. So they're pretty rare, although we have like a couple a year, I would say, that happen. This is part of the overlap between Sydney's presentation and my presentation. So if you recall, when Sydney was talking about someone being not competent and not restorable, that the court had a couple of other options at the end of that. And one of the options is that the court can order the prosecutor to file a petition for evaluation to start the Title 36 process. So again, you know, when Sydney talked about someone being not competent, not restorable, she mentioned that either the case can be dismissed, Title 36 proceedings can be initiated, or guardianship proceedings could be initiated. So this process is almost identical to everything I've already explained to you. All the same rules apply, with the exception of one. You don't need an application for emergency admission to start this process. And presumably that's because they're thinking to themselves, hey, this person's already gone through all these Rule 11 proceedings. We have a million evaluations saying that they have a mental disorder and that they're, you know, suffering from something as a result of that mental disorder. So you actually don't need an application for emergency admission. You skip that and you go straight to the petition for evaluation. But there's no guarantee that the person would end up on court-ordered treatment under this process, because it's the same exact process I just explained to you. And maybe the guidance center would evaluate them and feel that the person doesn't meet criteria for court-ordered treatment, or maybe they're voluntarily taking their meds when they're in the hospital. So it's not automatically guaranteed just because the person came out of Rule 11 proceedings that they're going to end up on court-ordered treatment. Oh, that's it.
Thank you.
Yeah.
I'll
Sure.
go in the chat and just check on these questions, if you have questions here. All right. If anybody has any questions, this would be the time to ask, but if not, we appreciate you being here today.
Yeah,
Does anybody in here have any questions? Yes?
So when you file a petition for Title 36,
Uh-huh.
how does HIPAA come into play with that?
Yeah, so it's still in effect, with the exception of for their attorney. So you know, I don't have to get my clients to sign a release of information to get access to their medical records. But this comes up all the time where patients don't want the doctors to talk to their families and give information. And so the doctors can't give information in those situations. But what can happen and does happen is those people can provide information to the doctors, of course. So the doctor doesn't have to release anything, but a lot of times families calling and saying, yeah, so they went off their medication 3 weeks ago, and since that time they decompensated, they got kicked out of their house, this, and this. And so the doctors are able to gather all this collateral information to support their you know, petition for evaluation, but HIPAA does still apply.
Okay, let's say we have an inpatient facility, right? So a client states that they got some SI with plan to execute, things like that, and we want a Title 36. How do we, I guess, protect ourselves, like, without giving away or breaking HIPAA petition?
Oh, I see what you're saying.
Yeah,
So I'm sorry, remind me again, you're at Granite Mountain?
correct.
Yeah. So
Are you saying you want to write the order on your client?
Yeah, exactly.
You
Like,
can, anybody can write an order on anybody.
you can still
So
fill
you
out
can
the
write
application.
the application, and then you have two options. You can bring the application to the guidance center, to the crisis unit, and then they will send it, and you say, okay, the person is at this address. Please go pick them up and bring them back here.
You're at Granite Mountain, right?
yeah,
You would
County?
go, yeah, so you would go somewhere in Yavapai County.
right.
Yeah.
What I'm saying is, like, I guess, like, the client is in our care, they're protected under HIPAA and everything like that. They say they're gonna go harm themselves and everything, that we write up the petition. Potentially having, you know, protected health information in there, you know, like the diagnosis.
Yeah, so I'm certainly no expert in HIPAA, so
Yeah, that wouldn't be HIPAA because you're writing something about somebody. The title has to be written about what you are actually seeing, like you're writing down, this person is saying this person has the plan.
Okay,
This
Yeah.
person is, you know, you're saying what you're seeing, that's not HIPAA, I mean, that's just what you're seeing.
gotcha.
And then
So-
you process it to wherever in your county you have.
So just leave out the things, just what we.
Yeah, if you're trying to be extra careful, you could stick to just your personal observations, yeah. And just to be clear, so you would not be the one who files the actual petition, it's just the application. And the reason why I'm bringing that up is because then it would be up to, you know, like an actual doctor to evaluate the person, to make determinations regarding a diagnosis and regarding their actual, you know, risk to themselves or others, so that in some ways that protects you a little bit. Mhm.
Gotcha.
Yeah, so there's nothing that HIPAA doesn't prevent the guidance center, for example, from filing all that information with the court to be able to proceed with their process. And it's mandated by statute for them to do so, obviously. Yeah. Yeah. Hope that helps.
Yes.
Yeah.
yes.
Awesome. All right, well, I think we will call it good. I appreciate everybody coming today. Appreciate you, Jillian, coming here to be with us, and yeah, thank you guys
Thank
for
you.
coming. And we will